morning. The May 6th meeting of the Senate Finance Committee will come to order. And I just want one routine business item at the beginning. I talked with Senator Pratt about this. Apparently the higher education policy bill, which is sitting in committee, they're asking we move it out. Higher ed passes a finance bill and a policy bill because the policy bill had one provision in that had financial implications, which we stripped out earlier. And so we're going to just simply move the bill forward now, nothing in it in finance. And with that motion, Senator Pratt moves that Senate file, House File 4252, the Omnibus Higher Ed Policy Bill as amended, be forwarded to the floor. Is there any discussion on that motion? If not, all those in favor say aye. Aye. Opposed? Motion prevails. Senator Clark, Senate File 5202, the Settlement of Claims Bill.
Good morning, committee. Good morning, Chair Marty. Senate File 5202 is the annual claims settlement appropriation bill. There is an A26 that you all will need to adopt so we can discuss it. That puts into the bill the individual appropriation, or the individual items.
Senator...
Mr. Chairman, I'll move it.
Senator Pappas moves the A26 amendment to Senate File 5202. Any discussion? If not, all those in favor say aye. Aye. Opposed? Motion prevails. On the bill as amended.
Thank you, Chair Marty. Established in 1976, the Joint Senate and House Subcommittee on Claims was created to hear and recommend whether or not to pay claims against the state by various people who cannot proceed against the state under the State Quorums Claim Act. The 2026 claims bill, as amended following our subcommittee review, appropriates approximately $5.1 million to resolve a small number of vetted claims against the state. And when I say vetted claims, you'll see that Mr. Keenley has the very large booklet of all of the claims that have come in. The committee or the staff goes through them all and painstakingly reviews them and says whether or not we should hear and provides a suggestion on them. Those claims, the majority are addressing wrongful convictions under the Imprisonment and Exoneration Remedies Act. The bill includes $250,000 for James Lamar Davis, who served about 3 years in prison before his conviction was vacated due to ineffective assistance of counsel. Second, there's $350,000 for Clayton Davis Groves, who spent nearly 52 months incarcerated before his conviction was overturned and he was acquitted on all charges at retrial. Lastly, there's $4.5 million for Marvin Haynes. He was wrongfully convicted at age 16, spent the next 19 years in prison before new evidence demonstrated his conviction was based on false evidence and unreliable identification, leading to the dismissal of all charges. The county court vacated his convictions and the charges were dismissed with prejudice. The bill also includes $4,570.40 for a Department of Corrections injury claim involving a permanent ankle injury sustained while working at MCF Stillwater, calculated under the standard statutory guidelines. Each claim has been vetted through an established process to ensure legitimacy and accuracy. This bill represents a balance of justice, responsibility, and due process. It ensures that when the state makes serious mistakes or when individuals are harmed in its custody, we respond appropriately. Thank you to Jason Keenley, Assistant Deputy Revisor and Counsel for the Joint Subcommittee on Claims, and his staff for the diligent work they did to bring this to committee.
Thank you, Mr. Keenley. Are there questions from the committee? Senator Draheim.
Thank you, Chair. Thank you for bringing the bill forward. And I understand it's our responsibility to take care of this, but I'm just wondering, are these all from state cases or are some of these from county cases?
Mr. Keenley, I think we'd be better at answering that.
Mr. Keenley.
Mr. Chair, Senator Draheim, they're all prosecuted they're prosecuted by the counties in most cases, but under state authority for those, and they're all all the imprisonments are under state imprisonment. They're doing state time.
Follow-up, Chair?
Go ahead.
Thank you. So do we ever have any recourse to the counties, or if there was a prosecutor or someone that made an error, to go back to the individual counties with, you know, I understand we have to make things right. I'm just curious. I don't deal in this area. I'm not on judiciary, thankfully. But I'm just wondering, is there any, I guess, recourse ever happen to charge back the counties per se?
Mr. Chair, Senator Draheim, so in 2014, the legislature passed the Incarceration and Exoneration Act, and that sets up the statutory framework for this. That statutory framework presumes all of these come through the state for this. If there were to be sort of a chargeback or a look back, there would be probably a need for a statutory change to the process pieces that happen there. As the process exists right now, it's all streamlined through the court system for the state.
Thank you. That's all I had.
Thank you. Senator Friends.
Thank you, Mr. Chair. Thank you, Senator Draheim. I think many of these are situations where the court system and both the prosecuting attorney and defense attorney acted in good faith with later evidence that the result was not the one the state was hoping for, and thus the claim. So a chargeback would normally be appropriate in an intentional malfeasance or something like that. Happy to talk more offline, but know a little bit about it. It's a great point. Thank you, Mr. Chair. Thanks, Senator Draheim.
Mr. Chairman.
Senator Pappas.
Mr. Chairman, following up with Senator Draheim's comments, I'm actually just curious which county these were from. Do we know which counties?
Well, Mr. Keenley's looking that up. I hope that Mr. Hayes has a good rest of his life. He must be 37 about now. Spent 20 years in prison.
Mr. Chair, Senator Pappas, I believe two of them are Hennepin, and the third one, I'm not sure what the third one is. I think I would have to look.
Mille Lacs.
Mille Lacs.
Chair Marty, yes, two are Hennepin County and one is Mille Lacs.
Thank you.
Senator Pappas moves Senate File 5202 as amended be recommended pass. Is there further discussion on that motion? If not, all those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Mr. Keenley and Senator Clark.
Thank you, committee.
Next, we're going to take up the cannabis bill. Senator Dibble is here, I'm told. Senator Hurd just walked in. We'll take up his bill then. Go ahead. Senator Hurd, the Outdoor Heritage Fund bill. Welcome to the committee.
Thank you, Mr. Chair, members. Today I have the honor to present the Senate File 4304, the Outdoor Heritage Fund Appropriation Bill. This bill is a result of 18 years of Outdoor Heritage Fund recommendation from the LaSalle-Sam Outdoor Heritage Council, passed through the Clean Water, Land, and Legacy Constitution Amendment in 2008. Statutory directive authorized the LaSalle-Sam Outdoor Heritage Council, of which I'm a member of, and so is Senator Lane, to review and recommend a proposal to the legislature that restore, protect, and enhance wetlands, prairies, forests, and habitat for fish, game, and wildlife through the Outdoor Heritage Fund. The Outdoor Heritage Fund is one of the four funds of the Legacy Amendment, receive 33% of the 3/8 of the 1% sales tax that use tax for legacy funding. Minnesota identity is deeply embedded to our lakes, streams, prairies, wetlands, and woodlands. The Outdoor Heritage Fund appropriation will help to protect, restore, and enhance these habitats for future generations benefit, and enjoyment. I thank you for your consideration of this bill, and now I turn over to our director, Christina Smitter, to present to you additional information.
Director Smitten, welcome to the committee. Please go ahead.
Thank you, Chair Marty and Senate committee members. Thank you, Senator Herr. Again, I'm Christina Smitten, the Executive Director of the Lessard Sam's Outdoor Heritage Council. And again, I want to thank you for the opportunity for me to testify in Senate File 4304 containing the Lessard Sam's Council's fiscal year 2027 recommended appropriations from the Outdoor Heritage Fund. Chair Marty and Senate committee members, I know you are familiar with the legacy amendment, but I will provide a brief overview of the Outdoor Heritage Fund, the Lessard Sam's Outdoor Heritage Council, and the recommendations before you today. As Senator Herr said, in 2008, voters passed the legacy constitutional amendment, which for 25 years provides for an increase in sales and use tax of 0.3%. The legacy constitutional amendment created 4 dedicated funds for outdoor heritage, clean water, parks and trails, and arts and cultural heritage. Of the 4 funds, 33% of these sales tax receipts are deposited into the Outdoor Heritage Fund to be spent to really, these 3 words are key: restore, enhance, and protect wetlands, prairies, forests, and habitat for fish, game, and wildlife. The governing Minnesota Statute 97A.056 establishes the Lessard Sam's Outdoor Heritage Council under the legislative branch to solicit and review requests and to make recommendations to the legislature for the appropriations of money from the Outdoor Heritage Fund. The governing statute requires at least 99% of money appropriated from the fund are expended for the purposes of the Outdoor Heritage Fund. The Lessard Sam's Outdoor Heritage Council consists of 12 members, 2 appointed by the Senate, 2 appointed by the House, and 8 citizen members, again, of which 2 are appointed by the Senate, 2 appointed by the House, and 4 are appointed by the governor. And similar to how your committee is supported by nonpartisan staff, the Lessard Sam's Outdoor Heritage Council is also administratively assisted by nonpartisan staff, including myself, and with me today is Assistant Director Joe Pavelko, and there's 3 other dedicated staff team members as well that support this good work. For this year's recommended appropriations, a call for funding was opened on April 1st and closed on May 23rd of 2025. There were funding requests totaling over $513 million. The Lessard Sam's Outdoor Heritage Council, based upon approved criteria, reviewed, scored, heard presentations from, and ranked proposals. The council unanimously approved the recommendations of funding appropriations for 53 programs totaling, with the February forecast adjustment, just over $191 million. The bill under consideration today is for 52 programs totaling $187,528,000. In your materials, members, is a map showing the locations of funded projects and a brochure with additional background and cumulatively proposed outputs in acres of prairie, forest, and wetlands protected, restored, and enhanced throughout Minnesota. Members, I'd like to point you to the front page and just pull out a few highlights found on this page of recommendations from this bill summary and the accomplishments that could be achieved by our 29 organizations and partners in the proposal in front of you. If the recommendations of the Lessard Sam's Outdoor Heritage Council move forward, we expect to see an increase of nearly 69,000 acres of wildlife habitat throughout Minnesota to be protected, restored, and enhanced, and an additional 40 miles of shoreline to be restored, enhanced, and/or protected. And with these appropriations and these programs, an additional over $15 million in federal, local government, and private conservation funding is expected to be leveraged. With that, Mr. Chair and committee members, I'll hold my comments and am available to answer any questions that you may have. Thank you.
Mr. Muir, go ahead.
Mr. Chairman and members, I'll quickly go through the spreadsheet. As a reminder, this legacy bill only includes the Outdoor Heritage Fund. The other 3 funds, the Parks and Trails Fund, the Clean Water Fund, and the Arts and Cultural Heritage Fund, were all appropriated for 2 years in last year's legacy bill. And the Outdoor Heritage Fund the appropriations are only 1 year at a time. So this year's legacy bill just includes the Outdoor Heritage Fund. The spreadsheet shows 2 columns. The first set of columns is the Senate File 4304 as introduced, and those numbers for each project were the original recommendations from the Outdoor Heritage Fund. After the February forecast, there was an additional little over $2 million that was available in the Outdoor Heritage Fund. So the Lessard Sam's Outdoor Heritage Council recommended additional funding kind of across the board for almost all the additional projects. So you'll see the final column difference from Senate File 4304 is the additional money that was sort of put back into the bill and spread across most of the projects. Also in committee, in the Environment Committee, one project was removed from the original bill, and you'll see that on line 35 of the spreadsheet. That is the Rosa Lake project. That was removed, and that money was not reallocated out, so that fell to the bottom line. So compared to the original bill, you'll see on page 2 of the spreadsheet, with the additional $2.159 million that was added into the bill, and then $3.553 that was subtracted out for the Rosa Lake project, there's minus about $1.394 million from the original bill. So that leaves on the last page of the spreadsheet, the statute requires that the legacy funds have a 5% fund balance. Right now, the bill as stands, there's a 7.3% fund balance in the Outdoor Heritage Fund. And so I'm not going to go through all the individual projects in the bill. The handouts that were provided go through most of them, but that's the structure of the spreadsheet.
Thank you, Mr. Mueller. Are there questions from members of the committee? Senator Howe and then Senator Johnson.
Thank you, Mr. Chair. And, you know, it looks like I think the number thrown out there was 69,000 plus acres going to be enhanced. How many of those are going to be acquired, of those acres are actually going to be acquired and taken off the tax rolls of these counties?
Ms. Smith, or Mr. Mueller, whoever.
Thank you, Mr. Chair and Senator Howe. In this, I'm going to point you to this brochure again. If you look on the second page, I believe the question that they're asking relates to the number of acres that will be protected in fee with PILT, the numbers of acres that will be protected in fee without PILT, and those protected in easement. And again,
Mr. Chair, follow up?
Continue.
Thank you. So am I under the understanding those that are protected in easement and those protected in fee without PILT, is the protected in easement, they continue to be owned by the landowner and continue to pay taxes, and those without PILT pay no taxes at all?
Mr. Chair, Senator Howe, good question. Yes, those protected in fee with PILT are not paying taxes. Those protected in fee without PILT and protected in easement continue to pay taxes. Often it's at a reduced rate, but they are continuing to pay taxes on those properties.
Senator Johnson.
Thank you, Mr. Chair. Is now the appropriate time to offer any amendments?
I think that would be reasonable, yes.
Okay, thank you. Mr. Chair, I do have the A11 amendment.
Senator Johnson offers the A11 amendment, and that will be distributed.
Maybe while it's being distributed, I can
Go ahead.
kind of briefly set the background for this one. So within my district, we've got a couple of projects that are happening in regards to floodwater mitigation. up there. And so one in particular is the Roseau Lake Bottom project. And that's what we heard about, the project that was removed from the bill at hand here today. There's another project that's downstream that is the Roseau River Rehabilitation Project, in which they're putting in bends and curves in that. And sometimes those two projects end up kind of getting mixed up between the two of them. And they interplay with each other. There's concerns by landowners, private landowners in the area about what the impact is going to be on their private land, both agricultural and otherwise. And so for the last 7 years, we've been trying to thread the needle between getting these flood mitigation projects done and making sure that we are protecting the private rights of the landowners up there. The county and the city of Roseau are very much in support of finishing up this project, which is about 60% done, as I understand it. And so there is a lawsuit that is being pursued. I don't know if it's been filed yet. There's been some injunctions on the project that are being proposed. But we want to make sure that we give those landowners who are contemplating that legal action some time to file it and to have a judge rule on that before the funds are released. And so what the A11 amendment does is it delays the funding once it's given till January 1st. That's at least 6 months then for the legal actions to take place. Or if there is an injunction given by the court that the funds would not be released. It also puts some burden on the watershed by reporting and doing some assessment on farmland and agricultural land that may or may not be impacted. I think this is a nice balance. It protects both sides of the project on it, and something I think can be moved forward here today to make sure that that project, if feasible, remains on task or on timeline and gets done. So that's my amendment, Mr. Chair.
Thank you, Senator Johnson. Senator Herb.
Thank you, Mr. Chair and members. As the chief author of this bill, I'd like to keep the bill intact as its original form, but in our discussion in the Environment Committee, members had some concern, and folks up in the northern region came down and testified, so very, very convincing. So we decided, the committee had decided to remove the Roseau project, just mainly of that reason. But who would know that area better than our good senator from District 1 that's in his district. So I would accept, although the language on adjoining lawsuit do, give me a little question, but I'm willing to accept the amendment, being that, we can tailor as it travel to the floor and through conferencing as well. So I'll accept the amendment.
And Senator Johnson, this is the same amount as originally proposed?
Mr. Chair, Council, that is the same amount, right? Just to double check.
Mr. Chairman and Senator Johnson, yes, actually the original amount that was put into the bill based on the November forecast was 3.505 million, but then when the February forecast came out and there was additional money put on all the projects, it was increased to $3.553 million. So that's the amount that was originally after the February forecast.
Is there further discussion on the A11 amendment? If not, all those in favor say aye. Aye. Opposed? Motion prevails. Further discussion, Senator Pappas.
Thank you, Mr. Chairman. I just shared this with Senator Draheim that I served with both Bob Lassard and Dallas Sams. And Dallas Sams unfortunately left us at a young age, but Bob is still with us. And we were planning to celebrate his 95th birthday at Mancini's, but unfortunately he's not in good enough health, so the birthday party had to be canceled. But certainly this has been a very proud legacy for both of them, and thank you for your work, Senator.
Thank you, Chair.
And to Senator Sams, has he been to any of the meetings to see his legacy being carried out in recent years? Senator Lassard, I'm sorry. Senator Lassard, has he been?
Mr. Chair,
I'm sure with both of them too.
he was here last year as my memory
Oh, good.
draw back, yeah.
Okay.
Yeah.
Senator Johnson.
Thank you, Mr. Chair. And I do have a couple other amendments as well, too. Would this be appropriate time to do that as well?
Go ahead.
All right, thank you. I do have the A13 amendment.
Senator Johnson offers the A13 amendment.
This is the term limits one, and it does make it retroactive. So if you wanted to have an oral amendment, Ms. Thanks. But somebody on the committee would need to offer. Thank you. So basically says that for public.
Senator Johnson, want to explain the amendment?
Thank you, Mr. Chair. This is an amendment that would put the council into compliance with what we see with other administrative bodies like this that do work similar to what we're seeing here at the Outdoor Heritage Fund. It puts a limit on the number of years that a member may serve on the council. So this is 8 years in particular. And so you'll see that the effective language is 2.16 through 2.17, and then the effective date down in 2.26 through 2.28 on there. That gives it the effective date of July 1st. So that is the amendment. I apologize to the author of the bill. This one came to me very late, so I just wanted to make sure that I wasn't trying to jump you with this or anything like that, but I just didn't get that until recently here. So I wanted to offer that amendment.
Senator Herr, on the A13 amendment.
Mr. Chair, as I say earlier, that I, like to keep the bill as its own original form, and we did add on an amendment which is part of the original, although there's language, a minor language change to give folks and resident in the rural area instruction. But this is kind of new to me as well, although I heard in the grapevine that this might be a possibility. And giving a term limit on the board, though we had the liberty to do that, we had the, as legislator, we had the independence to do that, but the committee is set up since the amendment in 2008, and there had not been a discussion within the council, the Outdoor Heritage Council. At the same time, it was not brought up during our environmental community when this bill was heard. So I think that it would be more appropriate if we could have gone back in time. This would be more appropriate then, but we are here now, and I'd rather not accept this amendment at this time.
Senator Pappas.
Mr. Chair, I was just wondering if Senator Johnson would just share why he thinks it's a good idea for kind of term limits on the public members. Senator Johnson, excuse me.
I'm sorry.
That's all right, Mr. Chair. Senator Johnson, why do you think it's a good idea that the public members have kind of a term limit?
Yeah, thank you, Mr. Chair and Senator Pappas. Appreciate that. From what I've been understanding, this is one where there really isn't a term limit on that. We want to see new folks that are on that board over time. I think that's the purpose of the public being on the board itself, is that we get new perspectives and ideas. And once you get somebody in there, this board has been around since, 2008, I believe. And so this, limits the opportunity for somebody to be on there for a very long time on that one. So to me, it makes sense. I know other councils, and we can talk with others who may know about other councils and committees that do it as well too. But this is kind of, from what I understand, unusual to have no term limits on this particular task force group.
Mr. Chair.
Senator Pappas.
Maybe Ms. Smitten could tell us, could tell us, do you have members that have served longer than 8 years, or does there pretty much people rotate off?
Mr. Chair, Senator Pappas, good question. Yes, we do have members who have served more than 8 years. Certainly, obviously, some members rotate off. The terms are for 4 years, and then they are the citizen members, again, those who have served longer have been reappointed. So yes, there are members. Currently, the chair and the vice chair have served more than 8 years. And there are, let me just look here so I make sure that I'm correct. And it looks like there would be one additional member who will be coming up on that 8-year citizen member. And there's one legislative member that has served longer than 8 years.
I'm going to encourage Senator Johnson to bring this up in a bill for the committee to hear. It seems to be, if this is a great idea to do, I think this is something that might be best heard in committee first and not put on an amendment in the Finance Committee. But I encourage you to pursue that route instead. Is there further discussion of the A13 amendment? Senator Pratt.
Thank you, Mr. Chair. And as I understand that these term limits on public members is not unusual, I'm just wondering if someone can help me with, do we have term limits on the LCCMR?
Senator,
I believe so, Mr. Chair.
he said, I believe so.
Yep.
So, Mr. Chair, this wouldn't, and Senator Hurd, do you recall what that term limit is? Is it 8 years or 2 4-year terms?
I don't recall on that, Mr. Chair and Senator Pratt. Let me see if Mr. Stanley would know.
Mr.
Or, yeah.
Mr. Chair, I'm going to run and get my computer.
And Mr. Chair,
Go
while
ahead,
Mr. Stanley is getting his computer, it seems like, you know, this is not outside the norm of what we've done with other commissions like this. And, you know, I think as Senator Johnson said, we need to bring in some new blood, some new ideas over time, not to let, you know, certain people or certain organizations get too entrenched in the process. We need to keep that. I mean, we as legislators that are appointed, I suppose, that's up to our caucus to swap us out. But for the public members, and to also increase the participation of the public and those that get to serve on these commissions, I think is important. It gets additional buy-in to what we're trying to do. I think this is a good amendment, Mr. Chair, and I hope once we get the answer from Mr. Stanley that we can adopt it.
Mr. Stanley, go ahead.
Mr. Chair, members, it looks like appointed legislative members of the LCCMR serve on the commission for 2-year terms.
Senator Pratt.
And thank you, Mr. Chair and Mr. Stanley. Is there a term limit on how many terms they may serve?
I'm reading as I grab the microphone. I do not see that. I'm going to keep reading and I'll let you know if I find it.
Senator Pratt. Okay, Senator Draheim.
Thank you, Chair, and thank you, Senator Johnson. This seems like a reasonable amendment, and I think I'm a big term limit guy. I'm term limiting myself out. I truly believe that the more people we get involved, the better the process is. And so I would fully support this amendment and urge my colleagues to do the same. Thank you.
Mr. Stanley.
Mr. Chair, members, I think I finally have the answer you've been looking for. There is language that says a citizen member of the LCCMR may serve no more than 8 years, except as necessary to fill a vacancy.
Okay. Again, when somebody proposes something like this in an amendment in committee, there's often a backstory to it and so on that we're not hearing and everything. I guess I feel more comfortable if a proposal like this, if it's a great idea, which I think it may be a good idea, but it seems to me that that's something could be vetted in a committee more thoroughly. And so I'd encourage us not to put that on as a Finance Committee amendment. Further discussion. If not, all those in favor.
Mr. Chair.
Go ahead, Senator Johnson.
Thank you, Mr. Chair. Well, we are in committee right now, so this may be a good time to do this. So maybe somebody at the testifying table might have just some advice on why this wouldn't be a good idea to match up with the LCCMR and other councils. I'm open to suggestions and reasons why. I think this is a pretty straightforward amendment and something that, quite frankly, could be taken up in this committee without a lot of harm to the process or anything like that. Very straightforward conversation here today.
Senator Herb.
Mr. Chair and Senator Johnson, when Bob Lazar and Dallas Sam set up this council, it took them years to develop a bylaw and all this rulemakings for them. So for us to make a decision in just a few minutes on changing the term limit is remain questionable. I think we have opportunity, this summer, as once we end the session, we're going to go and be busy talking about project that's submitted, and possibly that we'll be bringing this up for discussion. So I trust in having the board, the council, to have this discussion within themselves and bring the recommendation to us, instead of we making decision here in the finance and not even look at that. We didn't bring this discussion in the environment committee. So I just want to say that the appropriate way is the careful way, not a 5-minute decision. Thank you, Mr. Chair.
Further discussion. Senator Pappas.
Mr. Chair, I just want to say I think this is a good idea. I just don't think that out of respect for the author of the bill and the chair of the committee, we should offer it in finance. But at a later time, if I was still here, I'd be inclined to vote for it.
So further discussion on A13 amendment. If requests a roll call. Staff will take the roll.
Senator Marty?
No.
Senator Friends?
No.
Senator Pratt?
Yes.
Senator Champion?
No.
Senator Draheim?
Yes.
Senator Howe?
Aye.
Senator Jasinski?
Aye.
Senator Johnson?
Aye.
Senator Mohammed?
No.
Senator Murphy? Senator Pappas?
No.
Senator Wickland?
No.
Senator Murphy?
There being 5 ayes and 6 nays, the motion does not prevail. Further discussion. If not, Senator Johnson.
Thank you. Thank you for, I got one last amendment, the A14 amendment, if we may.
Senator Johnson offers the A14 amendment, which will be distributed. Do you want to explain it while it's being distributed?
Absolutely. Thank you, Mr. Chair. And this, again, is another one that was given to me recently here, just talking about the hiring process for the Outdoor Heritage Fund Executive Director position. They went through the process here recently, and I think there was some confusion, maybe some concerns on how the process was done overall. This is a way of just presenting it with a little bit more transparency, public transparency and integrity within the process itself, in case there was ever a situation where there was question. So if you look, there's language stricken at 2.20 through 2.24. A lot of that language gets shifted down into the new section at 2.27 through 3.7. With a couple of caveats in there as well too. So the council will still continue to have final approval on the authority or the approval authority on the executive director position. There will be a select number of people, this is the difference here, that will be asked from the council to interview and recommend candidates to the entire council itself. And this has to come out unanimously. If not, then it goes back with a couple of candidates that the full council can decide on. So it's more transparent out in the public on how it's done. And then finally, the executive director position would be hired at that point. Other than that, the rest of the language that you see within the 2.20 and 2.24 remains within that new section.
Senator Johnson, I really don't think Senate Finance Committee is the place to be reworking the workings of the Lessard Sam's Outdoor Heritage Council. I think that's something better for the Environment Committee. But Senator Herr, on the amendment.
Mr. Chair, Senator Johnson, although the instruction here in the bill is reasonable, but I still value the council that's been set up, and then they will be talking about this process later on this year and how it works. And one thing I would just want to share is that I serve in the Lessard Sam for, I believe, 3 years now. And so it has been nonpartisan in discussion. Senator Lane and I, although we're from different party, and most of the discussion we agree on. And so, you know, I don't know, it's slightly different from the LCCMR. Is, you know, the Lessard Sam appeared to me as less political. So to give them a direction here is, again, we're setting the cart ahead of the horse, and I would like to have a careful evaluation from the council and then recommend it to us, or we present it as a bill form to the Environment Committee. Thank you, Mr. Chair.
Further discussion, Senator Pratt.
Thank you, Mr. Chair. Well, just a couple of quick thoughts. You know, there's a number of us that are here that don't serve on the Environment Committee, and this is the first chance we get to see these things. And the Finance Committee is the last stop for these bills. And while we try not to do a lot of policy, we want to make sure that these bills have, you know, are in a good form to get bipartisan support on the chamber floor, and that's, I think, what we're trying to do here. So we seem to take a lot of policy without question from the majority members, but we seem to get a lot of pushback on the minority members, and I'm just trying to remind everybody that we want these bills to be in good shape over the entire, in order to get that bipartisan support. And it's not unusual for us to do this, to get the bill in the right shape before it goes to general orders. Thank you.
Senator Herr, was this bill heard in the Environment Committee?
No, Mr. Chair.
Senator Pratt, you're saying some of us are not on the Environment Committee. I'm not either. And therefore, we should be able to do it because we missed the discussion in the Environment Committee. The Environment Committee hasn't had any. I think I'm more concerned about Environment Committee members who haven't had a chance to look at this than members of our committee who haven't, because again, this is not, again, when these things pop up at the last minute and somebody's got a big change in this, unless the Lessard Sam's Outdoor Heritage Council is doing a terrible job, I really have concerns about us reworking their inner workings here with apparently some backstory going on that we're not being told about, because we gotta have term limits, we gotta change this. I just don't think that's the right place for this change. I think that should be debated in the Environment Committee. Senator Champion.
Thank you, Mr. Chair. In fact, Mr. Chair, you took a lot of the words right out of my mouth, and I know that's easy to do because I talk a lot, but I just want to just reiterate a couple of things. Number one is Senator Pratt is talking about Democrats versus Republicans and how folks come to the table and they take Democratic positions. I think that is unfortunate that he said that or that he even thinks that. And this policy provision should not first be seen, evaluated, or acted upon by the Finance Committee. The Committee of Jurisdiction should look at these important policies. This is not to say whether it's a good or bad policy. I'm not suggesting that at all, because that's not my place by which to do that. But any mechanism by which to avoid the committee process is not a good idea. And last but certainly not least, I think just taking merely political positions are dangerous for our committee and is dangerous for the committee process. So I would not I would not vote for the amendment that is in front of us, and I don't want it to be misconstrued that I am evaluating the underlying amendment. I'm merely saying that I think it should go through the process and be weighed and evaluated, and for them to make an important decision, and for that not to be the work of the Finance Committee. We're about numbers. And I think I heard other people say that. And I want us all to be on the same page. Thank you, Mr. Chair, for the opportunity to speak.
Thank you, Senator Champion. Further discussion, Senator Howe.
Well, thank you, Mr. Chair. The council makes recommendations, but it's the legislature that carries the responsibility for what goes out in the bill. And the council makes a recommendation. We have to do the scrutiny as to what this bill looks like and what we pass. And so I think that responsibility is that we got to make this the best we can make it. And whether that comes with a recommendation from the council or not, it's up to us to make this the best bill we can. And I take that responsibility to heart. So just to wave this off because it didn't come from the council, I don't think is right. I think we definitely need, we just made a couple of adjustments. I don't see why, just because these amendments didn't come in committee, we should waive this off. If it's a good idea and it makes it a better bill, we should do that. Thank you, Mr. Chair.
Senator Pratt, then Senator Johnson.
Thank you. Thank you, Mr. Chair. Well, this was a bill that wasn't heard in the Environment Committee, and I don't know why it wasn't heard, but it was Senate File 4462, Senator Lang's bill. Look, I'm not trying to make this partisan. I'm trying to do just the opposite, Senator Champion. I'm trying to make it nonpartisan. And that's why that's why we're talking about having a unanimous recommendation back and having both parties equally represented. That's, we're taking the politics out of it. We're trying to take the politics out of it. And I don't know why Senator Hurd didn't grant this Senator Lang's bill a hearing. It was introduced, back in March. But I think it's, if it's a good idea, as Senator Howe said, we should do it. Let's take the politics out of the Outdoor Heritage Fund and let's have it continue to be a process and a body that serves the entire state without looking at whether it's a Democrat or Republican. And Senator Champion, I never used those terms. You did. So I said minority and majority. Yeah, let's move this forward. Let's make this a good bill, and let's make it a bill that can get bipartisan support.
Senator Johnson.
Thank you, Mr. Chair, and I appreciate the discussion today, and I do think, along the lines of Senator Pratt on this one, this is our one opportunity that we had to look at this bill, to see some deficiencies within it, and to try to improve it. And I am a little concerned, though, with the conversation that is taking place as far as waiting for recommendations from the council to move forward to the legislature. It is the legislature that has created the council. It is the legislature that has put together the bylaws, put together the organization itself. And for them now to tell the legislature what to do is not the appropriate chain of command on this one. Where we see deficiencies or we see ways that we can improve an organization, it's our responsibility to take that opportunity and make those small changes. I don't think these are anything but good governance, both the term limits and also the hiring process, in which we see some deficiencies within that process itself. Right now, the legislature and state government in general is being scrutinized by all of Minnesota, by the nation, on the things that we have dropped the ball on, the public trust that we have taken advantage of over the years. And now we have really a national spotlight on our agencies, on our state legislature, on our governor. And this is a way of making sure that Minnesotans feel safe in the activities that our government is doing. When we're down here in St. Paul, what work we are doing. And so these are some very simple ways, and I know it's the Finance Committee, but this is our opportunity to put those on. This can be voted on today. We can do this today. So let's do our duty and do that. So, Mr. Chair, I ask for a roll call on the A14.
Senator Johnson requests a roll call. Staff will take the roll on the A14 amendment.
Senator Marty.
No.
Senator Friends.
No.
Senator Pratt.
Yes.
Senator Champion.
No.
Senator Draheim.
Yes.
Senator Howe. Aye. Senator Jazinski.
Aye.
Senator Johnson.
Aye.
Senator Mohammed.
No.
Senator Murphy. Senator Pappas.
No. No.
Senator Wickland.
No.
Senator Murphy.
No.
There being 5 ayes and 7 nays, the motion does not prevail. Further discussion on the bill. Senator Herr, any closing comments?
Thank you, and Mr. Chair and members, for working with me on this bill. And as I say earlier, I'd like to keep this bill as its original form, and it's going back that way with some input, with some directive input that are including mainly the Roseau project. And so, I'll carry this bill forward to support our outdoor heritage legacy, to enhance wetland, riparian, and forest. And also, lastly, I also want to offer congratulations to our newly hired director, Ms. Christina Smitter, as well.
Thank you and congratulations. Can you tell me once again, did the recommendations that came forward this year, the vote on them was that unanimous on all of the provisions?
It was,
Okay.
Mr. Chair. I don't know, I don't recall the detail exactly, but it was largely majority.
Okay, and with the Johnson amendment that put back the one project that had passed, it's now roughly, it's basically the same as what you had recommended. Okay.
Yes.
Senator Pappas moves Senator Howe on the bill.
I wasn't going to ask any questions, but because you opened the door again by asking another question, Mr. Chair, I do have a couple. One is, Senator Herr, did this bill, what its format today, are all the recommendations from the council in this bill?
Yes, all of them. I'll have Director Smitter, elaborate on the process. The process is quite broad. There's a formula that we take every time when the bill, when a project is proposed.
Mr. Chair.
Go ahead, Senator Howe.
Thank you, Mr. Chair. And Senator Herr, I guess my question is did the committee remove any projects that were recommended by the council?
I'll pass on to Ms. Director Smitter. As I recall, except the Roseau one has been removed.
That was the only one?
That was the only one.
Thank you. The other question I have is what fund does the PILT come out of the general fund, or what fund does the PILT come out of to pay that?
Director Schmidt.
Thank you, Mr. Chair. Good question, Senator Howe. The PILT does come out of the general fund to pay those taxes.
Mr. Chair, follow-up. So does that come out of an appropriation out of what committee? Out of the Environment Committee, or where does that come from?
Mr. Mueller, welcome back to the committee.
Mr. Chairman and Senator Howe, the PILT appropriation is an open appropriation out of the general fund, and the tracking of it is under jurisdiction of the tax committee.
Mr. Chair, follow up on that.
Go ahead.
So is there a reason why it doesn't come out of the Outdoor Heritage Fund for the land that we take out of that we pay that out of the PILT? Is there a reason it doesn't come out of the OHF?
Mr. Chairman and Senator Howell, that has been a question that has been around since the Outdoor Heritage Fund has been before the legislature. The discussion is largely centered around whether that's the constitutional use of the Outdoor Heritage Fund to pay the taxes portion of the land purchases. It hasn't been tried in court yet or anything like that, but largely the discussion has been that that is not one of the uses of the Outdoor Heritage Fund is to pay the tax, the PILT part.
Thank you, Mr. Chair. I think that's a discussion that should be taken up because it is all part of that acquiring and restoring and taking care of. If you're going to remove it off the tax rolls, that should be part of the Outdoor Heritage Fund cost of doing business. And if we need to make a constitutional amendment to make that happen, that's something the legislature next year should take a good look at. Thank you, Mr. Chair.
Thank you. Senator Draheim.
Thank you, Chair. I'll be brief. Just wondering how big is that PILT payment per year approximately? How big an impact would it be to the fund?
Mr. Chairman and Senator Draheim, the PILT payments are made for all land purchases that have happened even prior before the Outdoor Heritage Fund has been around. I'll look up what the current PILT payment is, but I would say most of the PILT now is for lands that were purchased before the Outdoor Heritage Fund. So partitioning part of that PILT out for what percent of it is due to land purchases since the Outdoor Heritage Fund has been around, I'm sure I could work with the council and try to get that.
Follow up, Chair.
Go ahead.
So do we have a fiscal note on this? I mean, if it's impacting the general fund, is that common practice and should it be in the future, I guess?
Mr. Chairman and Senator Draheim, we do not usually ask for fiscal notes for this bill, largely because we don't know exactly when the land purchases are going to happen. But I do have here the estimated PILT amount for this bill would be $324,000 in 1 year.
Perfect. Thank you.
Further discussion on Senate File 4304. If not, Senator Pappas moves Senate File 4304 as amended be recommended to pass. On that motion, all those in favor say aye. Aye. Opposed? Mr. Mueller and Mr. Stanley. With that, we have two more bills on the agenda. If we can finish before 10, we won't have to come back tonight. Senator Dibble, Senate File 4401. And Ms. Boyd and Mr. Mueller are switching sides of the table. Go ahead, Senator Dibble.
Thank you, Mr. Chair and members, for the opportunity to present Senate File 4401. I'll just forewarn you, we have a few amendments, so I'll just throw myself at the mercy of the committee to determine whether these amendments are more appropriate at another point in the process. But first, I'll just do a quick overview of the bill. There's only a small part that implicates finance, and that's in one of the amendments. Actually, no, I think it's more than just connected to one of the amendments. But anyways, just very quickly of the bill, Senate File 4401 is what is becoming our annual Omnibus cannabis bill, inclusive of both adult use and medical cannabis. It has several high-level goals to ensure a stable and well-regulated cannabis market, to protect and strengthen Minnesota's medical cannabis program, to streamline inefficient regulatory structures, improve enforcement tools against illicit actors, clarify local government authority, modernize labeling and product standards, protect proprietary business and consumer data, and improve market flexibility while preserving public health and safety. The major provisions are what we call streamlining, which is a proposal developed by the Office of Cannabis Management, OCM, to streamline Minnesota's medical and adult use cannabis supply chains. Under current law, medical and adult use inventories and operations must remain completely separate. This has been identified by a wide array of stakeholders as inefficient, burdensome, and actually harmful to long-term access to medical cannabis. So that's probably the biggest conversation that's occurring right now on all things cannabis this year in the legislature. There are provisions that clarify the relationship between the Office of Cannabis Management and local governments regarding zoning, fire code, building code compliance, certification timelines, registration caps, and compliance reporting. There are numerous OCM requested improvements to licensing and enforcement authority, including allowing business structure changes without requiring entirely new licenses, clarifying authority against illicit and unlicensed operators, improving endorsement structures, modernizing operational flexibility, and improving enforcement mechanisms. The bill also prohibits cannabinoid vapor products with embedded non-removable batteries due to environmental and disposal concerns. So that is the bulk of the overview of the presentation. And then we can talk a little bit about another bill that was traveling. It had to be carved off and sent through a slightly different path, so it's sitting here in finance.
Should we take it one amendment at a time, Senator Dibble, and that you can explain that one as we?
Yes, and I will ask Director Tobble to help me explain the bulk of the amendments. I'll give him a glancing explanation.
Did you want to start with A6 or A3 then?
Why don't we start with the A3? That's the technical coordination fixes to clarify it kind of, with the different proposals, changes were made that now have to be reconciled. All these R words. So this amendment will clarify endorsement structures, align transportation terminology, integrate medical cannabis endorsements for micro businesses and meso businesses. So it kind of synthesizes the supply chain streamlining measure with the overarching cannabis regulatory updates. So that's the A3. Director Tobble, anything to add?
No, that's really it. There were,
Go ahead.
Chair, the proposal to streamline was separate from the agency's other policy bills, and now that is moving forward, this just aligns the agency bill's proposal on the issue of endorsements with the streamlining proposal, since it changes the name of one of the license types. So this makes sure that those other proposed changes now make sense.
Further, Director Tobble, could you introduce yourself for the record?
Apologies, Chair. My name is Eric Tobble. I'm the Executive Director for the Minnesota Office of Cannabis Management.
Senator Pratt.
Thank you, Mr. Chair, and I was wondering if Ms. Boyd could tell me what the financial impact of this amendment is.
Ms. Boyd, first of all, Senator Friends will move the A3 amendment to put us in front of us. It was Director Boyd, excuse me. Ms. Boyd, could you go through the fiscal impact of this?
Yeah, Mr. Chair, I accuse her often of being a senator in the transportation committees.
Mr. Chair and members, the A3, I believe, is a streamlining and technical amendment put forward by the office. And my understanding is that there's no cost related to it, but I hope that the Director can confirm that for me.
Director Tobble.
Mr. Chair, Senator Pratt, thank you for the question. There is a small technology cost associated with changes to license types. However, the office is prepared to absorb that cost, so there's no cost associated.
Mr. Chair.
Further discussion of A3 amendment, if not all those.
Mr. Chair.
Senator Pratt, I'm sorry.
Senator Dibble.
I was just going to identify the dollar amount. I think it's about $13,000.
13,000, okay. I
Which
did not
the
hear that.
office is prepared to absorb.
Okay.
Mr. Chair.
Senator Pratt.
Thank you, Mr. Chair. And was there a fiscal note then that shows that $13,000? Was this a bill?
Mr. Chair and members, this was not a separate bill. There was not a fiscal note requested on this.
Further discussion on the A3 amendment.
Mr. Chair,
Pratt.
we just went through this conversation. It feels more like it's a policy than it is a real financial issue. The financial issues seem to be incidental rather than truly part of the amendment. And I just want to remind the chair that I got a long lecture on bringing policy provisions to the table.
Senator Pratt, I will often encourage members not to bring policy amendments. This bill is largely technical changes, and the amendment seems to be continuing that. So again,
Mr. Chair.
it's been offered. Senator Pratt, I'm not, you
Thank
can
you.
vote for or against it. Yes.
Thank you, Mr. Chair. And I would just maybe correct the record. Staff has just said that the 13,000 is attached to the A6, not the A3 that's in front of us. So this truly is just a policy amendment.
Is there further discussion on the A3 amendment? If not, all those in favor say aye. Aye. Opposed? No. Motion prevails. On the A6 amendment, Senator Dibble, that's you can explain it, but Senator Friends moves the A6 amendment to put in front of us. Now, this is the one that has 13,000 on it, and who wants to explain the amendment?
So, Mr. Chair, I'll take the first stab, as I do, hoping I get it right. So the A6 amendment is the language of my Senate File 4542, which is resting here in the Finance Committee. And it has to do with cannabis event organizer license structure. Currently, organizers must obtain a temporary authorization for each event. So what this amendment does instead is it converts that to an annual renewable license. It allows for the approval of a temporary cannabis event of up to 4 days. It simplifies the administration, improves predictability for organizers in the Office of Cannabis Management. So it's a $13,000 cost in fiscal year 27. Of course, in the coming biennium, that would be double the amount, and the Office of Cannabis Management has indicated that that is something that would meet their established budget.
Senator Draheim.
Thank you. And Senator Dibble, thanks for bringing these amendments forward. I know it's frustrating when I had a liquor license for 20 plus years doing offsite events. Part of the permitting process for an event is to review all the event criteria, security, who's going to be at the event, where is it located. With these proposed changes, would that affect any of those areas? Or would it just be an open permit to, or license to sell at any event? How, just, can you explain how that would work real quick?
Senator Dibble or Director Taubel?
So, Mr. Chair, I'll let Director Taubel answer substantively, but I would just draw members' attention to pages 4 and 5, which describes much of what is being asked for of the applicant at the outset, and then pages 6 and 7, which shows how to control for, manage, and have the information that you just described on an event-by-event basis.
Mr. Chair, Senator Ham, thanks for the question. To your question, it doesn't really actually change any of the underlying requirements or conditions to hold an event. The change is really that currently events get licensed one off at a time. So if you had an event at your liquor store, you would go get a license. It would last for 4 days. It would go away. And anyone's eligible to get those in the current system. The proposed change basically creates a person who gets licensed to host the event so that the office has an ongoing contact with an event organizer that we can work with across multiple events. The idea being that they would become expert and skilled at adherence to those kind of requirements around fencing, age gating, and importantly, we don't change any of the requirements that events really have to be before they even come to us. Because each event the organizer hosts would independently have to get approved and licensed by the office. And each time that occurs, it would also require local approval for that event before we take that step.
Thank you.
Further discussion of the A6 amendment? If not, all those in favor say aye. Aye. Opposed? Motion prevails. We have Senator Dibble. What, you have other amendments, did you say?
Yes, Mr. Chair. We have the A9 amendments.
A9 amendment is in the packets, and Senator Mohammed moves the A9 amendment. Could you explain the amendment?
Thank you, Mr. Chair. So this grows out of an initiative, I believe that is being jointly led by Senators Umu Verbatim and Coran, which grows out of a task force work on psychedelic drugs as medicine. This one particularly focused on psilocybin therapeutic use. And the short version is that following the signing of an executive order by the president, I think $50 million is being made available on either a competitive or first come, first serve grant basis for states to apply for, to take a look at whether or not establishing a therapeutic use program for psilocybin might be feasible and advisable. And so this would direct the Office of Cannabis Management to keep their eye out for the opportunity to apply for those funds through this mechanism that's described in the amendment. All right? All right, thanks.
Discussion on the amendment. If not, all those, Senator Pratt.
Thank you, Mr. Chair, and Senator Dibble. Why wouldn't this psilocybin go through the Board of Pharmacy rather than through the OCM?
Senator Dibble.
That's a great question. I don't have a good answer for you. I think probably for the same reason, well, I'll try to fashion a good answer. I think it's similar to, medical cannabis in that it's still considered an illegal drug federally. And so with, I don't know, is it on Schedule 1?
Yes.
Yeah, so it's on Schedule 1. So similarly, I mean, cannabis is now Schedule 3, but for a long time was Schedule 1. So the ability to work through the more traditional structures that have been set up around these kinds of substances is inhibited. And so, pharmacists, medical doctors, et cetera, feel like there's some implication for their license. And so we create these kind of workarounds to access these kinds of substances in this way, that has potentially positive therapeutic benefits, but because of legal designations like scheduling, it's hard to do that.
Senator Pratt.
Thank you, Mr. Chair. Well, it's my understanding that the Board of Pharmacy regularly sees all kinds of drugs that are used for medical purposes. And if that's what we're talking about with psilocybin, it seems like a better fit than maybe the Office of Cannabis Management because if I recall, and you were the author of the bill, Senator Dibble, so I'll defer to you on this, but when we passed medical cannabis, I thought that went through the Board of Pharmacy as well.
Senator Dibble.
Thank you. Mr. Chair, no, I don't remember any engagement with the Board of Pharmacy. I remember an active attempt to actively distance because, you know, there are these, you know, these legalities that, you know, doctors and pharmacists, you know, so no one, for example, prescribes cannabis for that reason. We do have pharmacists who are on staff at the medical cannabis retail settings to advise, you know, so the mechanism that occurs now is a doctor can certify that a particular patient has a condition. That's something that happens over here. So then there's a list of qualifying conditions over here. So then that means that that patient can now qualify to purchase and can enroll and become a registrant in the medical cannabis program. They can go to a retail outlet, talk to a pharmacist who is knowledgeable about the various formulations, et cetera, you know, and, you know, kind of what the use protocols look like and give advice. But there's still a shield, if you will, that protects them from violating their license. Doctors are shielded from violating the terms of their license. So it's kind of a workaround. And these, you know, these official entities, whether it's Board of Medical Practice, Board of Pharmacy, et cetera, they've really never wanted to get involved in what are still classified as federally illegal substances. Did you have anything to add?
Mr. Chair, Senator Pratt, I would also just note historically that when the THC hemp-derived products were first legalized, they initially were routed to the Board of Pharmacy for oversight and enforcement and implementation, and ultimately they moved to MDH and then subsequently to OCM. And so I think Senator Dibble's correct that some of the complications around licensed medical professionals handling what are otherwise illegal products creates complications for the board. And then I'd also just note, like, trend-wise across the country, psilocybin programs are launching. Many states are sort of embedding them in their cannabis offices and sort of a natural medicine office approach to products that are somewhat similar.
Senator Pratt.
Thank you, Mr. Chair. And Senator Dibble, was this provision heard in the Commerce Committee when the bill was there?
Senator Dibble.
Mr. Chair, I am told it was not. This provision in and of itself, I think, is a recent, more recent idea. The bill that was introduced was, you know, the bill that Senator Cran presented on the floor as an amendment that he then withdrew. It does set up the whole entire psilocybin program, and I don't think that was heard.
Senator Pratt.
Thank you, Mr. Chair. And Senator Dibble, was this heard in any of the health committees?
Senator Dibble.
Mr. Chair, do we know? I don't think so.
Mr. Chair.
Senator Pratt.
Thank you, Mr. Chair. And was this, because it's a Schedule I drug, was this proposal heard by the Judiciary Committee?
Senator Pratt. Senator Dibble, I'm sorry.
Mr. Chair, Senator Pratt, maybe I can jump ahead if you're going to continue to ask. I don't think this bill is heard at all, so.
Further discussion, Senator Howell.
Well, thank you, Mr. Chair, and Senator Dibble. I think this therapeutic program, these psychedelics offer great help for those of us that have dealt with PTSD, and I listened to a lot of tests. Once I heard it was going to be tested by the federal government and looked at there, that, you know, the ibogaine piece of this is really interesting to me. My concern is, though, is that those that I listened to testimony on that have gone through this program in Mexico, because it wasn't available here, doesn't sound like it's a very nice treatment. In fact, they have explained that it's probably one of the scariest things that they've ever gone through in their life, but it did fix them. It rewired their head to where they now function. But with that, I truly believe that my concern is it didn't go through the normal path and go through these other committees that actually, that we just heard, have the jurisdiction of some of this, that should look at it. And we just had a couple of amendments that, because it wasn't heard in the committee where it probably should have been heard, we didn't adopt it. And I think this falls right in that line. Not to say I look at this as it should be, I like the idea of going there. I just think it needs to be heard in those committees and set us up for success. Because I think this is going to really help a lot of us that have dealt with the PTSD problem and provide us a lot of treatment. But I'm a little bit worried that we're throwing this in without actually doing due diligence through the committee process and having it heard in the committees that actually have more jurisdiction and probably better expertise than we do. And I use expertise cautiously because you don't know my definition of an expert, so we'll go there. Thank you, Mr.
Senator
Chair.
Wickland.
Thank you. Yeah, I just wanted to comment. I think this amendment came about because of recent actions, and I think Senator Dibble, you may have mentioned this, but I think what Senator Curran and Senator Verbaeten were hoping to do was to be able to examine if there are federal opportunities for some funding for a trial or a pilot program that we could investigate and have an opportunity to participate in that, because the task force or the task force had developed recommendations about doing a pilot program. Senator Verbaeten had worked quite diligently on the pilot program bill, and just, I think recently, most of the concerns that had been raised, to my knowledge, about the boards had raised some concerns about who the providers would be to participate in this pilot. Those things had been addressed, and so we ran out of time to be able to hear, because that didn't happen until after deadlines. So we didn't hear the bill in my committee, but I know discussions were going on about refining that language. This amendment, though, is not, authorizing the pilot. It's just to make sure that they can continue to look at these federal funding opportunities. And my reading of it, it would just be information that they could evaluate whether there were options for participation. But I don't think that we could move forward with anything unless a bill, gets passed to do that. So I think it seems like the opportunity that Senator Curran and Senator Verbaeten talked to me about was, since this federal funding is first come, first serve, it would be helpful if we could, have some kind of proposal available to move forward with. So that's all I know about it. So thank you.
Is there further discussion on the amendment? If not, all those in favor say aye. Opposed?
Aye.
No. Chair's in doubt. All those in favor raise their hands. And those on screen, okay, you raise your hand that way too, okay. Let me check. Those opposed? By a vote of 5-4, the motion does prevail. Further amendments?
Let's see here.
I see A10 and 11 in the packets yet. And I will mention to the committee, we have Workers' Comp Advisory Council bill, which would be very brief, and also we did not send the right motion out on that other bill that we were just passing on. We sent the House language out. We didn't put the Senate amendment on, so we have to reconsider that for a minute. We would have to meet after session today if we cannot pull ahead, or we coast, well, Senator Dibble, you have 2 more amendments in the packet?
Correct. If we could jump to the A11 first.
Senator Dibble, Senator Friends offers the A11.
Mr. Chair, this has to do with allowing for elements of hemp derivatives to be added to cannabis products called a ratio product, currently allowed in medical, not allowed in adult use. So this would kind of bring that together with some differences, of course, because we have limitations on potency on the adult use side, and we disallow artificially derived cannabinoids from coming into the adult use side, which are allowed in medical. And I'll have Mr. Tobble help me explain a little better.
Director Tobble.
Thank you, Mr. Chair. Yeah, the products are products that are edibles, topicals, transdermal products, tinctures, oils, things like that. Many times, patients or adult use customers may be interested in products that have higher cannabinoids other than THC, so CBD, CBN, CBG. Those products, in order to, currently are prohibited from having hemp-derived products and cannabis-derived products together in the same product. Because those non-intoxicating cannabinoids are more prevalent in hemp, there's an efficiency in extracting them from hemp to put them into these products for the adult use and medical markets. And so this just cleans up what was, that those products are allowed in the adult use side and what the requirements and conditions are for their packaging and labeling.
Is there a discussion on A11? Senator Pratt.
Thank you, Mr. Chair. Ms. Boyd, is there a financial impact to this amendment?
Ms. Boyd.
Mr. Chair and members, I am unable to answer that question. There was not a fiscal note done on this language. It involves the definition of a new product. It may have cost to systems or forms. I'm unsure, but I would defer to the director of the office for that question.
Director Tobble.
Mr. Chair, Senator Pratt, in the, Senate File 4401, when it was combined, we did provide a fiscal note that noted that number of the changes did have de minimis costs associated with implementation around technology, but they were all at such a level that the office was comfortable absorbing those costs.
Senator Pratt, we can get that fiscal note passed out. Senator Pratt.
Thank you, Mr. Chair. And Senator Dibble, was this proposal then heard in Commerce?
Senator Dibble.
Thank you, Mr. Chair. Senator Pratt, it was not.
Senator Pratt.
Thank you, Mr. Chair. Senator Dibble, was this heard in Judiciary?
Senator Dibble.
Thank you, Mr. Chair. So the, actually, I'm trying to remember, maybe Mr. Tobble, the idea had been discussed at either one or both of the hearings. I can't remember which one or if both. So the idea was discussed and somewhat, but not actually taken up and included by amendment or as a bill. Mr. Tobble, do you remember where it was brought up and discussed?
I don't recall which of the 2 hearings it was, but there was public testimony taken where advocates encouraged this particular change to allow for these products.
Senator Pratt.
Thank you, Mr. Chair, and thank you for the fiscal note. It does appear that the fiscal note officially says that there's no cost, so I would presume this is predominantly a policy amendment. Thank you.
Further discussion of the A11 amendment. If not, all those in favor say aye.
Aye.
Opposed? Motion prevails. Further amendments. Senator Dibble, I see one more in the packet. Is that yours or?
Yes, Mr. Chair. I'll invite someone to offer the A10 if we could.
Senator Friends offers a 10 amendment. Go ahead.
So, Mr. Chair, the A10 is reflective of conversations that have been occurring with respect to the streamlining proposal, which I opened up by saying that is probably the element of the larger bill that's getting the most attention, something that's been talked about for a number of years for obvious reasons. The reason I am, of course, very attracted to the streamlining proposal is because it's, I think, an elegant solution to the problem that presents, is coming to the fore here in Minnesota and has occurred in other states where access to medical cannabis wanes, dissipates, vanishes once there is an onset of the adult use market for a lot of reasons: cost, efficiency, access, proximity, all of those things. This is a nice synthesis of the adult use and the medical use market, but it raises a lot of questions for folks about the growth and the entrance into the marketplace, the role of the existing medical incumbents, which are very large players in this space, and so all the various members of the industry have been coming together to talk about what might make sense in terms of some adjustments and some tweaks. So this reflects that conversation that's happening very positively in good faith. So this is an attempt to reflect the progress to date that has occurred in good faith, the agreements that have been the fruit of those conversations as we continue on to the floor and ultimately to conference committee. So it has to do with the existing conversion of licenses, the conversion of existing licenses as they might be moved from micro to meso to macro size, as well as new entrants into the market that would come in at the macro level. We would put that off until 2030. There would be a limitation. The big discussion is size of canopy. If anyone doesn't know what canopy is, spend some time in my office. I'll bore you to death talking about that. 2 acres down to 1 acre, which would be comparable to the equivalent of 40,000 square feet of a greenhouse, what we call canopy. Limiting the macro businesses from doing both, so they wouldn't have double the amount. The concern is that the very, very large players would come in too quickly and shove out the other entrants into the market, from other sectors or the micros and the mesos who are from Minnesota, which is kind of one of the original aspirations of the bill, underlying bill itself. So that's a description of the compromises that we've gotten to thus far, and more to come, especially around this canopy discussion.
Senator Friends.
Thank you, Mr. Chair. And in the interest of time, for my colleagues across the aisle who may have questions about this, I want to reassure the Finance Committee that in commerce, this was, as the bill came through, a topic of discussion. Senator Dibble is to be complimented. And as we talk about what policy and budget should come through the committee, just a reminder that sometimes committees out there, like Senator Klein's Commerce Committee, actually say, we're going to pass your bill, Senator Dibble, but we expect more work will need to be done. And the A10 amendment is one of those situations. I'm just flagging, Mr. Chair, that while there's some policy in here, sometimes the committees will say, go work on it, Senator. We'll see you in finance. And I'm a yes on the A10. Thank you, Mr. Chair, and thank you, Senator Dibble, and to the stakeholders that worked out this compromise.
Further discussion, Senator Jasinski, then Senator Pratt.
Thank you, Mr. Chair. Just frustrating. It seems like the majority gets to put their policy in and the minority doesn't get to put their policy in this committee today. That's frustrating. That's not the way government should work.
Senator Pratt.
Thank you, Mr. Chair. Ms. Boyd, is there a fiscal impact to this amendment?
Ms. Boyd.
Mr. Chair and members, I believe there is no fiscal impact. There are absorbed costs related to updating some licensing systems in the underlying bill, and these would adjust dates related to that somewhat, but it should not change the cost of that.
Further discussion on the A10 amendment. Senator Draheim.
Thank you, Chair. Senator Dibble, on the 2 acres down to 1 acre, an acre is 43,560, by the way. What are there any existing companies that would be affected by that shift in size? And is there a grandfather clause in your bill?
Senator Dibble.
Thank you, Mr. Chair. I will phone a friend.
Director Taub.
Thank you, Chair. Thank you for the question, Senator Draheim. The license, the macro business would currently convert two existing, what we call med combo businesses. Those two businesses, under the current existing law, are allowed to grow different amounts of cannabis for the medical market and the adult use market through separate allocated canopies. The combination of the two for indoor grows is around 90,000 square feet. By and large, the way the medical combination business license is written is it only allocates indoor grow. And so from like this particular amendment of 2 to 1, the outdoor allowance is a difference between the macro business license that we propose in the streamlining versus the current medical combination business license in Chapter 342.
Further discussion?
Well, I didn't really hear an answer, Chair, on if these two businesses are grandfathered in then, and where are these businesses located, I guess, is what.
Director Taub.
Chair, Senator Ham. The existing businesses, there's no sort of, they don't stay in the same boat. They get moved over to this license, so they come over and enter this license. I'd also note that the office, as part of its oversight of the implementation of the new medical license, has engaged in physical measurements of the canopy space for the two incumbent medical providers. Those we've done two separate measurements, neither of which has reached yet 45,000 square feet of actual used canopy. So their existing current usage, as the office has measured it, is below what the proposal is within this provision. As for location, I believe one is in Eagan and the other might be in Amber Grove Heights, but I'm not good at locations, so I will apologize if I got that wrong.
Further discussion, if not, the staff will take the roll on the A10 amendment.
Senator Marty.
Aye.
Senator Friends.
Yes.
Senator Pratt.
No.
Senator Champion. Senator Draheim.
No.
Senator Howe. Senator Jasinski.
No.
Senator Johnson. Senator Mohammed.
Yes.
Senator Murphy. Senator Pappas. Senator Wickland.
Yes.
Senator Murphy's now back.
Senator Champion.
Yes.
Senator Johnson. Senator Murphy.
Yes.
Senator Pappas.
Senator Johnson's here now, too.
Senator Johnson.
You can't influence my vote. No.
There being 6 ayes and 5 nays, the motion does prevail. Is there further discussion on Senate File 4401? Senator Howe.
Thank you, Mr. Chair, and I still have the same concern. I gave recommendations from the first day one that we had this cannabis bill up. Senator Dibble, and maybe the director can tell me this, but if you've got a cannabis business out in majority of greater Minnesota where the counties nor the locations have a building official or state fire marshal or a fire guy at all, who is verifying that these businesses are safe to operate?
Mr. Chair, Senator Howe, thank you. I appreciate the question. And as you know, we had conversations last year about this issue and the sort of, I think, general gap that these new cannabis businesses don't even really show up in some cases in state fire and building code. What we've tried to do with the changes that are sort of on lines, I think 9.23 through page 10, is make clear that the compliance with local building and fire codes isn't dependent upon having a local jurisdiction that is required to adhere to it, and that the applicant is responsible for ensuring that they have complied and providing evidence of that compliance to the office during the application process, whether that's through the county or the city that has that authority or a third party who can verify compliance with the code.
Follow up, Mr. Chair?
Continue.
Thank you. So what you're telling me is what kind of verification would they have to provide you if they don't have any of the above? Can they just say they comply? What is it, just an attestation? They just check a box and say, yeah, I comply?
Mr. Chair, Senator Howe, we've seen some examples where businesses have contacted other jurisdictions, their fire chiefs for help, or having third-party inspectors. I believe DLI has certified inspectors and DPS has fire code officials as well. And so we've seen a number of those be resources people have used to ensure compliance with code.
Mr. Chair, well, I'm a building official and a fire official, and I have some of that delineation or whatever you want to call it, that I can go out and inspect certain state facilities. This one hasn't popped up on my radar from DLI. So my concern is that is there a reason why we haven't gone to DLI and the State Fire Marshal's office to request them to do these inspections to keep the public safe out there? What is the reason why they haven't been contacted to provide those inspections? As we do in hospitals and schools and everything else where we want to keep people safe, why hasn't that gone that direction?
Mr. Chair, Senator Howe, I appreciate the comment. We've engaged with other government agencies, DLI, and others to try to figure out sort of, what the best path forward is. I think especially recognizing the concerns you had raised with the office in our conversations before hearings last year. I think certainly this is, like I say, we've tried to identify and update and provide fixes to address the situation as best we can, understanding that there probably still needs to be work to be done to get us to a place that makes the most sense possible.
So, Mr. Chair, more of a comment. I'm not going to belabor the point because from the start of this process, we have tried to make this a safe operation and have people actually have the inspections done to keep people safe, as we do in many other occupations. But in this case, we decided we're in such a rush to get this done that we really don't care whether we're doing the safety. We're just going to say, if you didn't get it done, you're waived. We're going to issue the license. That, to me, truly concerns me on the way we're going in the direction this is going. Thank you, Mr. Chair.
Mr. Chair.
Senator Dibble.
That's not entirely accurate. I mean, I'll draw everyone's attention to page 13, line 1, where it says a license can be denied if the applicant fails to demonstrate that the proposed cannabis business location complies with local zoning ordinances, the state fire code, or the state building code. So,
Mr. Chair,
it doesn't waive anything.
Senator Howe, go ahead.
Thank you, Mr. Chair, and I will direct you to line 9.32, where it says the office may waive the requirement and issue the license regardless of whether the office has waived the local government certification, and the proposed location must meet the requirements of this chapter. So as you go down that road, who is going to testify that they failed to meet the state fire code or the state building code? Who's checking that, Senator Dibble?
Thank you, Mr. Chair. The reason for the language on line 9.32, it doesn't waive whether or not the applicant can demonstrate that they comply with zoning ordinances, state fire code, or state building code, but this is trying to strike a balance between the business's right to locate and start operations, and some, frankly, actions on the part of local units of government that are outside of state law to try to stop those from happening and locating in their jurisdictions. So that's a balancing effort on lines 9. Line 6, I can't, I'll just defer to Mr. Tauble, trying to get, making sure that there is compliance with fire code, with building code, with zoning ordinance, et cetera. But we're trying to strike that balance so that folks who have made investments and, have spent a lot of time, we're all for small businesses, right? That's what I hear a lot in this Senate and in these committees. And, regulation is the boogeyman of entrepreneurship, yet that's what's being used to thwart people's ability to start businesses in a lot of places, and so we're trying to strike that balance.
Senator Pratt.
Thank you, Mr. Chair. Well, Mr. Chair, after being admonished on the previous bill for the Outdoor Heritage Fund, and despite what Senator Frentz is trying to get ahead of, we have adopted the A3, the A9, the A10, and the A11, all which have no financial or fiscal impact to this bill. After being told that we shouldn't be adopting policy in this committee, we adopted 4 DFL policy amendments. It sure seems to me, Mr. Chair, that there's hypocrisy going on in this committee, where members of the minority are held to one standard and members of the majority are held to another. But with that, certainly the A10 that was adopted on a roll call vote is extremely concerning, because it's my understanding, I'm just getting some notes here, that there is a building in Senator Lucero's district that relied on the 2023 law, and now it appears that the A10 is taking that authorization away. So it doesn't seem to be a peace in the valley type of amendment, Mr. Chair. I move that Senate File 4401 be referred back to the Committee on Commerce.
Senator Pratt moves that Senate File 4401 be referred back to the Committee on Commerce. Is there a discussion on that motion? If not, staff will take the roll.
Senator Marty?
No.
Senator Frentz? Senator Pratt?
Yes.
Senator Champion?
No.
Senator Draheim?
Yes.
Senator Howe?
Aye.
Senator Jasinski?
Aye.
Senator Johnson?
Aye.
Senator Mohammed?
No.
Senator Murphy?
No.
Senator Pappas? Senator Wickland?
No.
Senator Frentz? Senator Pappas?
On a vote of 5 ayes and 5 nays, the motion does not prevail. Is there further discussion on Senate File 4401? If not, Senator Friends moves that Senate File 4401 as amended be recommended to pass. On that motion, any further discussion? If not, staff will take the roll.
Senator Marty?
Aye.
Senator Frentz?
Yes.
Senator Pratt?
No.
Senator Champion?
Yes.
Senator Draheim?
No.
Senator Howe?
Aye. Oh, excuse me.
Senator Jasinski?
Nope.
Senator Johnson?
No.
Senator Mohammed?
Yes.
Senator Murphy?
Yes.
Senator Pappas? Senator Wickland?
Yes.
Senator Pappas?
By a vote of 6 ayes and 5 nays, the motion prevails.
Thank you,
And
Mr.
with
Chair,
that,
members.
Thank you, Senator Dibble and Director Tauble and Ms. Boyd. We have two quick things to deal with, if committee is able to do that. The first one is the bill we adopted earlier, we were just passing out the higher ed policy bill that we had stricken the finance things out, but we passed it the House file without changing the language to the Senate language, which is what we intended to send out. So Senator Pratt moves to reconsider that motion. Reconsider the vote taken on House File 4252. On that motion, all those in favor say aye. Aye. Opposed? Motion prevails. Now, Senator Pratt moves the title and contents of House File 4252 be stricken and replaced with the contents of Senate File 3943, which is the Senate version, the higher ed policy bill that had the finance thing stripped out and what we were intending to pass out. On the motion that the language in House File 4252 be stricken and replaced with that, all those in favor say aye.
Aye.
And then on the motion that House File 4252 as amended be sent to the floor, all those in favor say aye.
Aye. Aye.
Opposed? Motion prevails. Then real quickly, we got the Workers' Comp Advisory Council recommendation. Senator McEwen, can you do this quickly?
Sure can.
If we get this done, we do not meet after session today. Senator McEwen, Senate File 3720, the Workers' Comp Advisory Council recommendations.
Thank you very much, Mr. Chair, members. The Workers' Compensation Advisory Council, as I think all of you know, is a statutory labor employer council that negotiates reforms to the workers' compensation system before recommending a consensus bill to the legislature. The agreement in Senate File 3720 is the result of many months of work by the council's business and labor caucuses and key workers' compensation stakeholders. I'd like to thank our colleague, Senator Udke, who is a co-author on this bill, and my counterpart on the council, and I ask for your support.
Is there discussion from members of the Finance Committee? If not, Senator Friends moves Senate File 3720 be recommended to pass. On that motion, all those in favor say aye.
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 Opposed? Motion prevails. And with that, we've completed the business for this morning. We're planning to take up the Omnibus Ag Bill on Friday, the Program Integrity Bill tomorrow. Tomorrow we're taking the Omnibus Ag Bill, and Friday, apparently, the Program Integrity Omnibus. We're starting at 8:30 tomorrow in this room.
Mr. Chair.
Senator Pratt.
Mr. Chair, we had a brief conversation yesterday. I was wondering if there's any way we could try to move both those bills tomorrow.
Could you, staff, could you tell us why we can't take a Program Integrity tomorrow?
I think Program Integrity folks are still working on the bill, and we'll need until Friday to be ready for Finance Committee.
So,
Senator Pratt.
thank you, Mr. Chair. Well, Mr. Chair, that doesn't seem like it's complying with our rules on having information available 2 days before the hearing. If we're going to hear it on Friday and they're still working on it. So I would suggest then we look to push that out to Monday.
I'll take that under consideration. We maybe do that if we can work it out calendar-wise, we will. With that, this meeting is adjourned.